Sakshi TV's special immigration show with attorney Ms. Prashanthi Reddy from the Law Offices of Prashanthi Reddy PLLC. Please note that Sakshi TV now has 3 immigration shows every week on Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with attorney Prashanthi Reddy in English, and on Friday at 6 p.m. EST with attorney Bhanu Ilindra. Please tune in to ask your questions. If you're an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided in this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Prashanthi needs no introduction, but if you need consultation, please log on to reddyesq.com for contact information. And when you connect with them, don't forget to mention Sakshi TV. From the beginning, reddyesq.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The reddyesq.com site provides you with latest and cutting-edge information on US immigration law and policies explained in terms you don't have to be a lawyer to understand. Today's topic is the immigration news and updates, and we will continue the knowledge session along with the news and updates on latest immigration followed by Q&A. Before we get into the topic, you can call us on the numbers on the screen for questions related to immigration and also ask for tips. Hello, Ms. Reddy. How are you doing?
I'm good, Tharni. How are you?
Very well, thank you. So, before we get into the topic, it's Thanksgiving. So, we wish you a happy Thanksgiving to you and our viewers from the entire team of Sakshi.
Thank you, and same to you and everyone who's listening.
Thank you so much, ma'am. So, could you please tell us what are the updates for this week?
So, our entire show is going to be about updates. So, let's go get to the updates directly, Tharni.
Right. Yes, ma'am. So, could you please tell us about the employment authorization for H4E and L dependent non-immigrant dependent spouses update?
Yes. So, with reference to that, we have some. Well, it's good news, but it's not as good as we wanted it to be. But there's still hope. But with reference to that, basically the update is that. Just to give you first some background about what the problem is, and then I will tell you what the solution they found and what possible solutions might be found in the future. We're talking about H4 dependent. H4 dependents are H1 spouses, basically dependents of H1s, and we're also talking about L dependents, so L2s. And E dependents as well. So the problem with the H4s, which is they're the H1 dependents, is that from the past couple of years, USCIS has been taking 12 to 18 months to renew H4s and also renew H4 EADs. So as we all know, some H4s can work. And in order to work, they need an EAD approval. So that's a different application that has to be filed, and usually a H4 extension or H4 change of status or whatever it might be is filed along with an EAD application, which is I-765. And both applications are taking forever. And the problem is that once an EAD expires, you have to stop working. So we're talking about people who are filing their extensions. You cannot file your extensions more than 6 months in advance. Okay, so it's not like you can file it a year in advance, and therefore even if the USCIS is taking a year, you can compensate for that. So you can only file 6 months in advance. So what's happening is people are not getting their EADs for a year or more, a year and a half, and they can only file 6 months in advance. So they are pretty much without an EAD for about a year, no matter, and this is not because of their doing. They're filing it as soon as they possibly can, as soon as is allowed by law. So we're looking at situations where the spouse is out of work for a period of a year or more. And as we know, people who have lucrative jobs or any jobs, no employer is going to wait for a year. Right. And keep their job open. So they're pretty much losing their jobs.
Right.
And so it's not only losing their jobs, it's losing the maybe the health insurance that is related to that job, which might have been running the family. It's losing that additional, the now if you're used to two incomes coming in, you only have one coming in. So it's a hardship in every which way. We're talking about the mental hardship, going through the stress of not having to lose a lucrative job, but not working when you're used to working. All this is mental trauma as well. So all these things put together, it was a very difficult situation for families to be in. So there has been some litigation recently with reference to delays in filing in processing of H4s, and there was litigation also to allow H4 some kind of an automatic renewal of EAD, so that while it's pending, they can still work.
Right.
So, and because this is the case when you file an EAD based on a 485, which is the green card, but it's not the case when you're filing for EAD renewals based on H4.
Right.
So, with reference to the automatic renewal part, there was a lawsuit, and USCIS has come to an agreement. So this is like a settlement agreement where the judge is actually not giving a verdict, but the USCIS, knowing that they will lose or not wanting to go through a lengthy trial, decided to agree on certain things, and so both parties come to a mutual agreement, and they decide to do this out of court, settle out of court, and therefore not have to proceed with the legal the case. So in this case, it was decided that basically USCIS agreed that there will be a 180-day extension on H4 EADs, or the person can work for the duration of the I-94, whichever is less, not whichever is more, but whichever is less. So it's either the duration of the I-94 or 180 days, whichever is less. So this is really not as useful as it could have been, because in most instances the I-94, the extension and the EAD is being filed at the same time. So H4, I-94 extension and EAD is being filed at the same time. So in most cases they cannot use this rule because there's no I-94 period.
Right.
So the only time they can use it if the H4 is still valid, but the EAD has expired. Or they can use it if they file both at the same time, but the I-94 gets approved faster, and the EAD is still pending, then they can at least work for that 180 days or the duration of the I-94, whichever is less. So in some limited circumstances this is good, but otherwise not so much.
Right.
With reference to L2s, it's very good news, because for L2, so L dependent spouses are called L2s, and they're allowed to work as well. And as per the law, actually, L2 does not have to apply for an EAD. They're automatically work authorized. But USCIS has been insisting on filing EAD applications for L2s as well. So that they have come to a settlement and agreement on that. USCIS has agreed that L2s do not actually have to file EADs, and they're automatically work authorized once they get an L2 approval. So that's great news, because again, L2 EADs were also being...
You were talking about the L2 dependent visas.
Yes, so I was just saying the other good news. With reference to L2 dependents, we definitely have good news, because we don't need to file for EADs for them. They're automatically work authorized. So as soon as anyone gets an L2 approval, they can start working immediately without the need to file a 765.
And on that good news, we had a caller, and we still have our caller on hold, Mr. Kumar from Chicago. Thank you for calling, Kumar. You may ask Ms. Reddy your question directly.
Yeah, thank you, Torni. Hi, Ms. Prashanthi. This is related to question related to... Yeah, I'm doing good. Thank you. So the question is related to USCIS CSPA. So when final action date is current, 485 and 140 applied together, with that the child age is locked or not? Or if the 140 is approved after the date is retrogression, what happens? The child age is locked or not? That is the question, Ms. Prashanthi.
So when you file the 485 at the date of, it's a very good question, by the way, because not many people, it's very useful to a lot of people and not many people will know this. So if at the time of initially filing the 485, the case is filed based on not dates for filing, but it is filed based on final action date, then the child's age freezes. So even if the child is 20 and it takes 3 years for you to actually get your green card, because the 485 again retrogresses, again becomes current, again retrogresses, we see that happening, correct? Because USCIS is not able to process cases on time when they become current, and then they retrogress after a month. So yes, the answer to that question, I think you got it already, that if the child is under 21 and if you're filing a 485 and if you're filing based on final action dates, then the child's age is frozen.
I applied the 485 together. I applied, but the 140 is approved after retrogression.
It really doesn't matter. I-140 doesn't matter. Whether it's approved, not approved, you file concurrently, already approved, it doesn't matter. As long as the I-140 is filed and it has not been denied, you're good. And the 485, it's important. What is important is that the 485 was filed based on final action dates.
Okay. Thank you, Ms. Prashanthi. Thank you.
Right. Thank you for calling, Mr. Kumar. Right. So, Ms. Reddy, you was telling us about the good news for L2 dependent visas.
Right. So, I think, I basically have conveyed the fact that, L2s can work without an EAD or without having to file an EAD application. And not to lose hope, there is pending litigation to still address the issues that have not yet been addressed in the settlement agreement with reference to the H4s and their EADs. So there's a litigation that is challenging USCIS with reference to delays in processing of cases. And they're asking the judge to order USCIS to process EADs immediately or within a specified period of time to avoid long delays. So we don't know what's going to happen with that, but at least we have some hope because there is something pending. With reference to documentation, what you need to show that for the I-9 purposes, right? So I-9 is where you verify your employer based on immigration documentation to show that they are authorized to work. So for the I-9, to fill out the I-9, since the EAD is not valid, you can't use an expired EAD. As per the new rule, you have to submit the I-94, your I-94 unexpired I-94, your EAD receipt that you have filed, and the expired EAD. So those are 3 documents that you have to submit for I-9 verification purposes if you're able to use that 180-day automatic extension rule for the H4 EAD.
Right. So, Ms. Reddy, we also received some FAQs regarding the COVID-19 travel after the travel ban is lifted to the US. So, and here are some of them. So, the first one is, does one need to be fully vaccinated against COVID-19 to enter the US?
Most international travelers entering will need to be fully vaccinated and show proof of vaccination before boarding any US bound flight.
Right. So, and does one need to be fully vaccinated if they are an American citizen or are a lawful permanent resident?
So, the exception, of course, there are always exceptions to everything, and this has been there has been no travel ban pretty much for US citizens and permanent residents. So, in that same in light of the same thing, they have said that US citizens and green card holders do not need to show proof of full vaccination. They can either show that or they have the option of showing a negative COVID test which was taken 24 hours before departure.
Right.
So those who have fully vaccinated, they need to show also a COVID test needs to be done, but 72 hours before departure, not 24 hours.
Right. And
So while
who's
both, yeah.
right? And who's exempt from the vaccination requirements?
So in addition to that, the children under 18 are exempt because in many countries they don't have vaccines for children as yet. Certain COVID-19 trial participants, so some people who are taking part in a trial for COVID-19 vaccine, they are exempt. Humanitarian reasons, emergency reasons, there's always an exemption under this category for everything. So, they always put this in. It's difficult to get. It's decided on a case by cases, but yes, for emergency or humanitarian reasons, they have put in an exemption there. Those traveling from countries with very low vaccine availability. Now, if there's no availability of vaccine, you can't force a person to get vaccinated because they want to, but the vaccines are not available.
Right.
Members of military and their immediate family members, airline, ship crew members, diplomats and their families. So these are the categories that are exempt.
Right. And the next question, I think, is kind of a very important question. Which are the vaccines that are accepted?
Right. So even before, when they were talking about the travel ban being lifted,
Right.
there was questions about which vaccine will be
Right.
available, especially for
There's a
people
huge
from India
debate
where they
between
have different types.
Covaxin and Covishield and Sputnik. I
Covishield
mean, everybody
and
who got
Sputnik
Covaxin
and
then basically freaked out.
yes, because they were worried that it
Yeah.
won't be accepted.
Right.
So, but basically, what CDC is saying that all those vaccines that have been approved for emergency use by the World Health Organization (WHO),
Right.
they will be accepted, and that's Pfizer, Moderna, Johnson and Johnson, AstraZeneca, Covaxin, Covishield, Sinopharm, and Sinovac.
Right. So Sputnik is not a part of this.
No, Sputnik is not.
Right. So, and what are the acceptable forms of proof of vaccination?
So the common sense, they've just followed common sense here, and they said that you have to show us a digital proof, or you can show us paper proof that you've been vaccinated, and you also have to give us your ID so that we can compare to make sure that it is in fact your vaccination.
Right.
So basically ID and proof of vaccination in the form of an online or paper version.
Right. And are the children who are traveling supposed to take a pre-departure COVID test?
Yeah, so children between 2 and 17 are required to take a COVID test before they travel. And unvaccinated children traveling with fully vaccinated adults will need to show proof of a negative test within 3 days of travel. And those children traveling alone or with unvaccinated adults as opposed to vaccinated adults will need to show proof of negative test taken within 1 day of departure. So the 24 hours, the same as the previous requirement, 24 hours versus 3 days,
Right.
72 hours.
Right. So, Ms. Reddy, I think that those are the FAQs on COVID-19 vaccination requirements that we've received. And we are moving on to the next immigration updates. So, could you please explain to us the specialty litigation updates?
Yeah, so this is a very important breakthrough that we have received with reference to immigration law and H-1Bs mainly, because now one of the major reasons that you get denials is based on specialty occupation. So they basically saying that the position that you filed your case for is not a specialty occupation and therefore, not eligible to get a H-1B. And within that specialty occupation, they're saying that it's not a specific specialty. So the explanation of this is basically there is a book called the Occupational Outlook Handbook, OH in short, which is an online book and also, it's in print as well. So the USCIS usually looks at this book to see what, for each position, what the educational requirements are. So if the OOH says, for example, that a systems analyst or a marketing research analyst position requires a bachelor's degree, say systems analyst, in engineering, computer science, physical sciences, etc., then immediately they were denying these cases, basically stating that it's the degree requirement is not specific enough. It is giving you a whole range of degrees, and it doesn't say, for example, computer science or related. For a software engineering position, the OOH says computer science or related, so they're okay with that because they're saying that's specific enough. So there has been some change with reference to this interpretation, and again, this change only took place because of the various lawsuits that were filed. USCIS will otherwise not change anything, if they're able to, and in fact, they will misconstrue the law and make it more difficult if they can, and that's what they've been doing. So in a case Madkudu Inc. Versus USCIS, the case was about a marketing research analyst occupation, and usually market research analyst positions have always been a problem simply because the OOH states that a degree in MBA, a MBA degree or a BBA, business administration degree is required, and a business administration degree is very broad because it doesn't say business administration in finance or in marketing, or it just says business administration. So they're saying that that is not specific enough, and therefore they were not approving these market research analyst cases. So they came to a settlement agreement where they said that if a case was filed between Jan 29 and October 2021 for a market research analyst, and if it was denied, you can file an appeal and they will accept. And if the case was denied only for this one reason, then they will accept the appeal and they will approve the case. So that's a big breakthrough. In the IT field, there are a lot of positions that stopped being available. For example, systems analyst positions, thousands of cases got approved, and then suddenly they put in the specific specialty requirement, and they closed the door for systems analyst positions, and which meant basically that employers had to go for higher positions, much higher positions, like software engineer, and compared to systems analysts, the software engineer salaries were much higher. So I feel that it was done intentionally so that they can remove all the middle grade tech people from the market, basically. So anyway, so this market research case really helps us with reference to even those other positions. We can use the same argument. Similarly, in March 2020, there's a case, Taylor Made Software Inc. versus Susinelli. So basically, the court said the same thing, that we understand that the degree has to be somewhat related, but it doesn't have to be in that specific field only. It can say it can be in a related field as well. It doesn't have to be in one particular discipline. It can be in multiple disciplines. So
because market research analyst is somebody who's actually a kind of a generic occupation that has a lot of academic qualifications. You can come from marketing side or you can come from any other side to be a market research analyst. So it's kind of a verdict that says if you need not have the specific any specific academic qualification. It can come from multiple disciplines. Is that what
correct?
This means?
As long as it's related. Yes,
right.
You understood that right. It can't be completely disparate, meaning you can't say that Bachelor of Arts is required or Bachelor of Science is required. There's no connection between an arts and a science, right? So it cannot be any field. You cannot say bachelors in any field. But for example, computer science and engineering are related.
Correct.
So it has to be somewhat related, but it doesn't have to be in one particular field. That's what they're saying.
So with that, we come to this. Yeah, please go on, Ms. Reddy.
Sorry. Yeah, so I just, this other case that I was talking about, 2020 case, the court basically rejected USCIS's conclusion that because the OOH allows for the possibility that some computer analysts do not hold at least a bachelor's degree, this means computer systems analysts are not normally required to have a bachelor's degree. So this was another point that they raised, again from the OOH, and they said that, we require the OOH to say that all employers should require a bachelor's degree. That's not needed. It doesn't say that anywhere in USCIS regulations. It is just they say that as long as the majority of the employers, the majority of the industry needs it, we're fine. We think it's a specialty occupation. But USCIS again, in their good judgment, decided that it should say that all employers need it, so they increased the burden of proof on their own unilaterally. So the court obviously disagreed with it.
Right.
So that's another good measure for us.
Right. With that, Ms. Reddy, we come to the end of the show. Thank you so much for the ton of updates that you've given us and the community. So it was a privilege, like always, hosting you. Thank you, Ms. Reddy.
Thank you. Bye-bye.
You're watching Sakshi TV Live with me, Torni Makana. Thank you.